A very warm welcome to all the listeners to these lecture series started by Abhimanyu IS, Law Simplified. I, Gurnoor Sandhu, advocate, practicing at the Punjab and Haryana High Court, has the golden opportunity to address all our listeners today on a very, very interesting topic, that is detention and writ of habeas corpus. I've been told that our listeners have already been addressed on the topic of habeas corpus in the earlier lectures. However, I intend to also talk about the connection of the writ of habeas corpus with that of law of detention, because without detention, the writ of habeas corpus is of no use. So before coming to the topic and its discussion in detail, I think it is very, very important for all the listeners to first understand the underlying concept behind both these terms, that is detention and habeas corpus. And the underlying connection between both of them is the right of personal liberty. Now, personal liberty is something that is guaranteed to each and every individual by the law of land, that is the Constitution of India, under Article 21. Personal liberty is basically freedom from physical restraint of a person by way of either incarceration or by any other means. It is interesting to note that on one hand, where Article 21 provides us the freedom or the right of personal liberty, on the very same hand, it also provides that personal liberty can be curtailed as per the procedure established by law. So we need to understand that what is the procedure as per which one's personal liberty or one can be put in restraint, he can be put in physical restraint. The two broad ways in which the law provides for restricting one's physical freedom or physical movement is one, arrest, and second, detention. Now, before I come down to the theoretical part of today's lecture, I must give you an example to explain as to first what is detention. We must all would be aware of the fact that when Article 370 was abrogated in the erstwhile state of J&K, now a UT, various prominent political leaders were detained. Their physical movement freedom was restrained just in order to make sure that the public safety and public good is maintained. So therefore, the very act of detaining such leaders was provided under the law, that is the Public Safety Act. Now, what we need to understand is firstly that what is the remedy available to a person, or for that matter to such leaders who were detained in the erstwhile state of J&K, what is the remedy available to them under the law to get free from such detention? Such remedy is called the writ of habeas corpus, for which one has to show that the detention is illegal. Now, before talking further about the concept of detention and writ of habeas corpus, it is my duty to firstly lay out a distinction between the concept of arrest and the concept of detention. Because if a person is arrested, he is arrested for committing a crime. Whereas if a person is detained, he is detained to prevent him from committing a crime. So therefore, the remedy which is available to a person who is arrested is that of bail, provided under the Criminal Procedure Code. And the remedy of bail cannot be resorted to by a person who is detained to get free from such detention, because he is technically not arrested for any cognizable offense. So therefore, the remedy available to a person who is detained is that of filing a writ of habeas corpus, that too when he is able to prove that the detention is illegal. Now, having talked about the distinction between arrest and detention, now we must discuss as to what is detention in detail and whether there is any law which provides for the power to the state to detain persons in view of securing public good and public safety or not. So now, talking about law, we need to divert our attention to Article 22, Subclause 4 of the Constitution of India. Article 22, Subclause 4 is the law which provides for preventive detention or legal detention. Now, we need to see that the object of detention is not to punish an individual who has detained the person. The object is to set free the person who has been detained illegally. So therefore, Article 22 of the Constitution, particularly subclause 4 onwards, provides for the safeguards to prevent abuse of preventive detention, because it is not a hidden fact that sometimes the state exercises its powers in a malified manner to illegally detain persons for political reasons, etc. So therefore, the Constitution itself, where on one hand it provides for the law of preventive detention, on the other hand also provides for the procedure in which the person is to be detained and the safeguards to prevent abuse of law of preventive detention. So I have summed up this Article 22 in 6 points, which I will be just stating the point of safeguards to prevent abuse of preventive detention. The first is, whenever a person is detained under the law of preventive detention, he must be furnished or he must be given the reasons for his detention within 5 days of such detention. Second is that the détenu, that is the person who has been detained, should be made aware of his right to make a representation against such detention. Third is that an advisory board should be constituted which would assess the representation made by the détenu and come to a conclusion whether such detention is legal or illegal, or whether it is justified or not justified. So the fourth is that once the advisory board is constituted, the case of the détenu has to be referred to the advisory board for consideration. Fifth would be, the advisory board is legally obliged to give a hearing to the détenu and see whether his detention is legal or illegal. Last safeguard that has been incorporated under Article 22 of the Constitution of India is that if the advisory board is convinced with the representation of the détenu and is of the conclusion that yes, the detention has been illegally made, then in that case, the advisory board shall revoke the order of detention if it deems fit in light of the facts of the case. So these are the 6 safeguards which are provided under the Constitution, the law of the land, to prevent abuse of law of preventive detention. Now, till now we have discussed detention by the state authorities under the laws. Now, detention can also be of another type, that is, when a private individual forcibly removes a person from a particular place and confines him in his own detention, or confines him, it takes away the person from a particular place and puts him, say, to place B without his consent and forcibly. Now, in that case, such removal of a person from his lawful place of being to another place against his will is also detention. And such detention can be called or referred to as illegal detention by a private person. Now, another example would be in cases of minors who are forcibly taken away from the lawful custody of their guardians. Even such action of taking a minor away, illegally taking a minor away from the lawful custody of the guardian, is also detention and illegal detention. So at this stage, we need to understand that detention per se is not illegal. It gets illegal when it is not done as per the law, or it is done by a person or an authority or a private individual who does not have the legal authority to do so. So therefore we need to see that what are the grounds of challenging such detention in the courts of law. There are numerous grounds. I have summed up 5 of them. One could be that the order of detention is not passed by the competent authority. Second could be that the order of detention lacks bona fide. It is visited by malefides and ill motives of the person or the authority who has passed it. Third could be the failure to follow the procedure which is provided under Article 22 of the Constitution of India, which we have just discussed. Fourth can be mere non-application of mind while passing the order of detention. Another ground could be that the order is vague, irrelevant, or passed under extraneous consideration or circumstances. So now that we have discussed a brief outline about the law of detention along with Article 22, we need to now understand that if a person is aggrieved by his detention and if he says that I am illegally detained, what is the remedy available to him? I will just take a pause and go back to the very beginning of our lecture where we talked about the 2 ways of curtailing one's personal liberty. One was arrest, second was detention. Now in case of arrest, the remedy lies in the Criminal Procedure Code, where a person who is arrested for commission of an offence files a bail application before the court, and if the court deems fit, the court releases him on bail, subject to payment of his bonds, sureties, etc. However, in case of detention, the person who is detained, that is the détenu, does not have he cannot avail the remedy of bail provided under CRPC, because bail can only be availed by a person who is arrested. So therefore, a person who is detained resorts to the remedy of filing a writ petition, a writ of habeas corpus provided under Article 226 of the Constitution of India and Article 32 of the Constitution of India before the High Court or the Supreme Court respectively. So now we need to understand the very basics of the writ of habeas corpus. It is always very important to understand the etymological meaning of the term habeas corpus before talking about the law on the same. The writ of habeas corpus, or the term habeas corpus, literally means to produce the body. So basically, when a court issues a writ of habeas corpus, it asks the person in whose detention a detainee is alleged to be, and the court will ask that person to produce such person before the court and justify that as to how such detention is legal. And if the court is of the opinion that the person who has detained the detainee has detained him under illegal grounds, or his detention is affected by malefides, then the court can very well order the release of such person from the detention. So therefore, there are two broad remedies under the writ of habeas corpus. One is before the High Court. One can file a writ petition under Article 226 before the High Court, or one can file a writ petition under Article 32 of the Constitution of India before the Honorable Supreme Court of India. However, there is a slight difference. If one is filing a writ of habeas corpus under Article 32 of the Constitution of India, then one has to show that the fundamental rights of the detainee are violated, whereas such requirement is not there while filing a writ petition under Article 226 before the Honorable High Court. Because even if there is a legal right being violated by the act of illegal detention, one can file a writ before the Honorable High Court, but not before the Supreme Court under Article 32, because Article 32 strictly provides for a remedy for violation of fundamental rights. So now we need to understand the object, that what is the scope and object of the writ of habeas corpus. Firstly, we need to see that the object of issuing a writ of habeas corpus is not to punish the wrongdoer or the person who has taken another person in his illegal custody. the object is to provide for an efficacious remedy to secure the release of a person who is illegally confined or illegally detained. Another important aspect of the writ of habeas corpus is the concept of locus standi. Now, we must all be aware of the fact that the Constitution of India under Article 226 and 32 provides for five writs in total. First is the writ of certiorari, then the writ of mandamus, then the writ of prohibition, and then comes the writ of quo warranto, and lastly, the present writ that we are discussing today, the writ of habeas corpus. Amongst these five writs, the first three, that is certiorari, mandamus, and prohibition, these three writs have a precondition which has to be fulfilled before filing, that is, that they cannot be filed by any other person except for the one whose legal rights or fundamental rights are violated. However, when we talk about the writ of habeas corpus and quo warranto, these two writs lay out an exception to the general rule of locus, and in these two writs, any person who is either related to the person, for example, in the case of writ of habeas corpus, brother, sister, your parents, can file a writ of habeas corpus seeking one's release from illegal custody. So therefore, the strict rules of locus standi which are applicable to these first three writs that I just stated are not applicable to the writ of habeas corpus, and anybody can file it. One need not show his locus standi before filing it. That is not a bar provided under the writ of habeas corpus. So, and this particular concept is very, very important to understand. It gets very important because if strict rules of locus are made applicable to the writ of habeas corpus, then it would be very difficult for the person who is already detained in illegal custody to come to the court and file a writ of habeas corpus, because his whereabouts are not known because he's been illegally detained. So therefore, the concept or the general exception from the general rule of locus standi, which is applicable to other writs, has to be there in the writ of habeas corpus, because it enables your near and dear ones to file a writ of habeas corpus before the courts and ensure that you are released from the illegal custody. Now, once your near or dear one has filed the writ of habeas corpus before either the High Court or the Supreme Court, another important question that comes for our consideration is that what is the duty of the authority or the person who is called before the court to state that as to why this writ should not be issued and as to how the person or the detainee is in your legal detention and not illegal detention. So in these cases, such person or the state authority has to show two things. One, the legality of detention. How will they show the legality of detention? Either they will show that a particular order was passed under a particular law which gives them the power to detain, and therefore they have detained the person by following all the provisions and procedures prescribed under law. Second would be to show that they have conformed with the mandatory provisions of the Act. So once the state authorities or the person who has detained another individual is able to show these two things and the court is satisfied, then they might not issue the writ of habeas corpus. However, on the very other hand, if the court is not satisfied on these two accounts, that is the legality of detention and conformity with the mandatory provisions of the Act under which they have detained the person, then they can very well issue the writ of habeas corpus and ask such person or authority to produce the detainee and release him. Now, another question that comes for consideration before us is what happens if a particular person or a authority refuses to obey the orders issued under a writ of habeas corpus by the court of law. Now, in such cases, if the person fails to produce the person before the court, or if he fails to release him from his illegal custody, then the court of law can very well issue contempt proceedings against him for violations of the orders of the court. Contempt proceedings call for penal consequences. One can also be imprisoned along with imposition of heavy fines. So therefore, contempt proceedings can be initiated if the orders of issuance of a writ of habeas corpus are not complied with. Now, another important question which is of great practical significance while dealing with the writ of habeas corpus is as to what would happen if, say, we file a writ of habeas corpus before the Honorable High Court under Article 226 and the Honorable High Court deems it fit to not interfere in the order of detention and deems it fit to not issue a writ of habeas corpus. Then what are the remedies available to a person who is aggrieved by the detention of his own or some near or dear one? In such case, there are two remedies. One, the person aggrieved by the order of the Honorable High Court can file a special leave petition under Article 136 of the Constitution of India, challenging the order of the High Court by way of which it refused to issue a writ of habeas corpus filed before it under Article 226. Another remedy for the person would be to straightaway go to the Honorable Supreme Court of India under Article 32 and file another writ of habeas corpus directly. So basically, the law is settled on this point that mere filing of a writ of habeas corpus under Article 226 of the Constitution of India before the Honorable High Court is no bar to filing a subsequent writ of habeas corpus before the Honorable Supreme Court under Article 32 of the Constitution, because here one has to show that what fundamental rights are violated. So there are two remedies. One is filing an SLP under Article 136 and second is to straightaway then go to the Supreme Court under Article 32. Now, another important question that we need to address, or a head that we need to address under this topic, is that when the writ of habeas corpus does not lie, or when can it not be issued. So the first thing is that, for instance, I file a writ of habeas corpus for person A before the Honorable Punjab and Haryana High Court, whereas the person is alleged to have been detained in the state of Rajasthan, say Jaipur. Now in that case, merely due to the lack of territorial jurisdiction, the Honorable Punjab and Haryana High Court will not be able to issue a writ of habeas corpus because they do not have jurisdiction over the state of Rajasthan. For that, one has to go to the state of Rajasthan, the Honorable High Court present there, and then file a writ of habeas corpus for seeking appropriate relief. So one bar is the bar of territorial jurisdiction. Second is, of course, if the detention has been made as per law, it is not illegal per se. So therefore, in such cases, no writ of habeas corpus will ever lie. Then would be that the person or authority who has made the detention, if that person or authority is not within the territorial jurisdiction of the High Court where we file the writ of habeas corpus, even in that case, the court would not interfere because it will be barred to do so, sheerly on account of lack of territorial jurisdiction. So these are few grounds, broad grounds, where a writ of habeas corpus may not lie. Now coming to the practical aspect. We all are aware of the fact that law is a very evolving concept. With time, law changes, new fields are added, new concepts are added. Similarly, the law pertaining to the writ of habeas corpus has also evolved. And by evolution, I mean that in present day, the writ of habeas corpus is also being sought by various persons for seeking child custody. Now, this is a very, very interesting topic because we all must be aware of the fact that child custody per se is a field or is a subject matter that is governed by various special enactments such as Guardians and Wards Act, etc., wherein the parent, whoever wishes to take the custody of the child, is required to file a petition under the specific provision of the Act and then lead evidence and show as to why the custody should be given. So therefore, on the very first blush, one may think that the writ of habeas corpus should not be filed in cases of child custody matters because there are special enactments which deal with it. However, as I said in the very beginning, that law is always an evolving concept. So therefore, as of today, the Honorable Supreme Court has had the opportunity to interpret and evolve the law pertaining to habeas corpus, especially in child custody matters. So I would like to cite a very, very recent judgment in the case of Yashita Sahu versus State of Rajasthan and others, reported as 2023, Volume 3, SCC, page number 67 onwards, delivered by the Honorable Apex Court itself. Now, in this case, the Supreme Court was confronted with a case where one parent was seeking custody of the child from the other parent. Both the parents were separated, and the question was pertaining to the custody of the child. An objection was taken in this matter by the parent who had the custody of the child, that the writ of habeas corpus is not maintainable because there are special enactments and the parent should be asked to file a specific petition for seeking custody under the special acts, as I stated, Guardians and Wards Acts, etc. However, the Supreme Court, after considering the matter at great length and considering the law which was prevailing by then, came down to a conclusion that the extraordinary writ jurisdiction of issuing a writ of habeas corpus can be resorted in cases of child custody matters also. However, it should not be made a matter of routine, and a writ of habeas corpus in child custody matters can only be issued when the party seeking the custody of the child is able to show that the interests of the child are not being taken care of, or if the child is permitted to stay in the custody of the other parent, then his rights will be, day-to-day rights would be severely prejudiced. So this is the broad parameter, or a broad parameter which one has to clear or one has to fulfill to before one can file a petition for seeking custody of a child directly by asking the court to issue a writ of habeas corpus. Another concept which is evolved in such cases is that the courts are always inclined to, while dealing with the writ of habeas corpus filed in child custody matters, the court is always inclined to at least issue some directions qua visitation rights. So this is another feather which has been added to the concept of the writ of habeas corpus in child custody matters by the Honorable Supreme Courts and the Honorable High Courts while interpreting the law on this issue, that they are inclined to issue orders of visitation rights. So from what we have discussed so far, initially the writ of habeas corpus was filed strictly for production of a person before the court who was alleged to have been illegally detained. Now, in cases of child custody, the question of illegal detention per se will not arise, because even if a child is in the custody of his or her father or his or her mother, his custody cannot be said to be illegal per se. So therefore, this is how the law has evolved, law pertaining to habeas corpus over the period of years has evolved, wherein even if the custody per se is not illegal, however, it is alleged that the interests of the child will not be met if he is permitted to stay with one of the parents. In those cases, the courts have been interfering by issuing writs of habeas corpus, and a very recent case I've already discussed, that is Yashita Sahu versus State of Rajasthan and others, reported as 2020 Volume 3 SCC 667. So this is the basic theoretical concept about detention and habeas corpus. Now, once we have discussed the theoretical part of it, now we need to understand that along with the theory, we need to learn the practical also. Because eventually, now once we are equipped with the theoretical knowledge about the law of detention, basic concept of detention, personal liberty, writ of habeas corpus, we must also know that how does one actually implement this theoretical knowledge in the courts, or how is the procedure involved in these cases. So basically, as I've said in the very beginning, that the remedy of filing a writ of habeas corpus is an efficacious remedy, and time is of great essence in such cases. So once, for example, as a lawyer, I can say this, that once a client approaches a lawyer or an advocate for filing a writ of habeas corpus seeking release of some of his relatives detained illegally, the case is filed and it is taken up on the very same day by the High Courts. And once the High Court is of the opinion, upon reading the very brief or the pleadings pertaining to the case, the High Court appoints a warrant officer. So basically, warrant officer is a person who is appointed by the court to go to the place where the person is alleged to be illegally detained, look out for him and get him released from such illegal custody and produce him before the court. So once the warrant officer is appointed by the court, he will proceed to the spot, provided that the place where the person is alleged to be detained is in the territorial jurisdiction of the High Court. That is a bar which cannot be relaxed. So once the warrant officer finds the person, he will produce him before the court and the court will direct his release. Now in this entire thing, in this entire procedure, we must be wondering then that what happens to the person who is found to have illegally detained an individual. So once the court has ordered the release from such illegal detention, the attention shifts as to what happens to the person who is the wrongdoer in this matter. At this point, I would like to say that the writ of habeas corpus has absolutely no remedy, no provision for punishing the wrongdoer. So there is no provision or there is no judgment of the Honorable Court which says that the person who has illegally detained another person and has been found to be guilty to do so can be punished under the writ of habeas corpus. That is not the law. So writ of habeas corpus does not provide for any punishment of such person. So now that we have also understood the practical and the theoretical aspect pertaining to the law of detention, it is my duty to give you certain recent examples where the writ of habeas corpus was filed to get prominent personality examples pertaining to prominent personalities whom we come across in newspapers, TV, etc. every day, where writ of habeas corpus was filed for their release. A very recent example would be that of one of the TV anchors, Arnab Goswami. Now, when he was taken away by the Maharashtra police, he was eventually released from the custody upon filing the writ of habeas corpus. So now we can understand that what is the importance of the writ of habeas corpus in day-to-day life. Apart from that, before concluding my session, I would lay stress on the fact that we must not confuse arrest and detention. Because if in practical aspects, if as a lawyer or as a legal practitioner, somebody comes to you saying that a person has been in custody of some authority, you have to decide, you have to come to a conclusion whether that custody is in pursuance to an arrest or is in pursuance to a detention. Because if you are not able to distinguish between both, then there could be a case where the person is actually under detention and you choose to file a bail application. That will be a total chaos. So basically, if the difference is between the concept of arrest and detention is clear to us, then only we can advise our clients as to the remedy. Because the remedy in case of arrest is the remedy of bail, and the remedy in case of detention is filing the writ of habeas corpus, which we have discussed in minute detail. With that, I conclude today's lecture. I hope that all the listeners would have able to learn something about these two very, very important concepts from what has been discussed today. Thank you.